Hello everyone, welcome back to the Legal Explorer. I am Advocate Romana. Today I am going to discuss a very important judgment of the Supreme Court of India in the case of Maniklal Sahu versus State of Chhattisgarh. The court has given a clear guidelines in this case on when an offence is murder under section 202 of IPC and when it is only attempt to murder under section 307 of IPC. This is very useful not only for the general awareness but also the students around the India who are preparing for judiciary exams, prosecutor exams, and especially for the upcoming assistant public prosecutor exams in all over in different states. Let's discuss the case. The facts of the case: the accused dragged the victim to the terrace. He beat him with the sticks and threw him down. The victim remained alive for 9 months but later died due to the complications like pneumonia, septic shock and organ failure. The High Court said this was not murder but only attempt to murder because death happened much later due to the lack of proper treatment. But the Supreme Court disagreed whatever the High Court said. The Supreme Court said that the survival for months or later medical complications do not break the chain of, and the injuries were so serious and there was an intention to cause death. So let's discuss the key guidelines laid down by the Supreme Court which will helpful you in writing in the theory of the mains exam for the upcoming judiciary exams. What are the key guidelines laid down by the Supreme Court in this case which will be helpful you while writing the mains exam for upcoming judiciary exams? So the first guideline is, if the injury is fatal and there is an intention to cause death, even if the death happens after complications, any such complications, it is still murder under section 302 of IPC. The second guideline is, if the injury are such that they alone could cause death, it's still murder even if the death occur later. The third guideline, medical treatment is irrelevant whether proper or improper when deciding if the injuries are sufficient to cause death. The fourth guideline, even if no single injury is fatal but combined injuries shows intention to kill the other person, it amounts to murder. And the fifth guideline is, courts must focus on whether the injury was sufficient in ordinary cause of nature to cause death, not on how long the victim survived or whether the treatment was given proper or not. So my dear students, these guidelines are useful for writing in your mains answer sheet for your theory exam. Suppose the question might arrive. Write the guidelines which are given by the Supreme Court in the latest case, landmark case. So you can write these 5 guidelines. If you want, I'll give you this PDF. You comment in my comment section. I'll give you the PDF of this 5 guidelines. So it will be helpful for your upcoming any judiciary exam. Compulsory you have to write these 5 guidelines and the case name in your answer sheet. Why this case matters? See, this judgment basically removes the confusion for the courts and the students, for the lawyers. But section 302 of IPC, which is murder, which defines that when injuries are fatal or and there is an intention to cause death. Section 307 of IPC is nothing but attempt to murder, which says that when the act shows intention but the victim survives and the injuries are not sufficient to cause death. So basically the Supreme Court restored the trial court's conviction under section 302 of IPC and said the High Court was wrong to dilute it section 307 of IPC. So basically conclusion for my students that, remember, the focus is always on nature of injury, intention, probability of death, not on how long the victim survived or whether the treatment was given properly or not. This judgment is a must known for the judiciary exams, prosecutor exams, and especially for upcoming of assistant public prosecutor exam for both AP and Telangana. So make a note, it can directly be asked in your mains or Viva. In Viva they can ask, can you please tell me the recent case law, recent case judgment which is given by Supreme Court, which has given a guidelines and differentiate between the murder and attempt to murder. So for APP exam, for assistant public prosecutor exam for both AP and Telangana students, mug up this case, refer this case. If you have any further doubts, you can comment in my comment section. I will help you for sure.